Hello, I'm Dan Marr from Hamlin, Carrigan in Nashville, New Hampshire. I've been practicing law for approximately 36 years here in New Hampshire and about 28 years in Massachusetts. I'm licensed and practice in both states. And today I'm going to be talking about in New Hampshire the various ways that people usually hold real estate, individuals hold real estate, and how that can affect what happens when somebody passes on, as well as what happens if there's creditors of one of the people holding the real estate. I'm going to start off with the way most people hold their residence is husband and wife will hold their property as joint tenants with rights to survivorship. Joint tenants with rights to survivorship means that basically both of them have an interest in the property, but when one of them dies, it goes automatically to the other one. So if you have a situation like a joint tenants rights to survivorship, your deed says that, then in that circumstance, one of you passes on, the other one gets it immediately. You don't have to go through probate, and it can be an effective way to pass real estate that way. One of the things that happens, though, is sometimes when you're not a married couple, you might be in a relationship, committed relationship, and you decide to purchase property together, and you buy it as joint tenants rights survivorship, and then the committed relationship is no longer a committed relationship. One of you wants to move on, or both of you want to move on. In that situation, you might be in a circumstance where you're concerned that one of you might take ill, and what happens if they die when you're trying to figure out a way to divide up the property. There's a process I've discussed before called a partition statute. It's another blog of mine you can look up, but that's basically a statutory way that you go through the court system and you divide up your property. If you have the property as joint tenants rights survivorship and you're concerned that you don't have the same relationship you had before and you want your half or your portion to go to your heirs, under New Hampshire law, there's several cases out there in the New Hampshire Supreme Court decisions that say that one of you, without the other side's permission, can break that tenancy, that joint tenancy, where you can, generally what you would do is you transfer it to maybe your son or somebody else, and they would your half interest, and they would immediately transfer it back to you. And the reason for that is to break the joint tenancy. And then you'd have what's the most normal way that people hold property called tenants in common, when there's two people holding the property, two or more, and that means that their percentage interest goes pursuant to their will, their trust, or whatever else they may have. So that's one way to deal with the issues. Another way that some people deal with it as the married couples or somebody that's even single, they might have a revocable trust. And a revocable trust means that it can be changed at any time that the person is competent, and it becomes irrevocable on death. When I say it can be changed any time that they're competent, usually those revocable trust provisions specifically spell out that a guardian can't go and change the trust, can't change the terms. Only the person that granted it, called the grantor or the settlor, is the one who's able to do that. And that makes perfect sense for protections of, I'm making a revocable trust, I want to make sure I'm treating it like a will, and I'm not going to have a guardian that's appointed by the court to do something unless I've stated specifically in my trust document that I want this person that I trust to be able to make these decisions for me. So you don't allow the court to make those decisions through a picking of a guardian. And that's standard provisions in a revocable trust. But in that situation, because it's a revocable trust, it's generally treated as your asset. So you can't think that if you have property in a revocable trust that creditors of yours can't go after it. They generally can go after it. You still have the homestead exemption under, if you own residence in a purely revocable trust, the statute allows for your $120,000 homestead exemption. That's beyond your mortgage and beyond your real estate taxes. You can have that type of protection there, but you do it for your residence, but it is a revocable trust, and therefore people can get at it. Another thing that people do, and the last one I want to deal with, is sometimes a person might be saying, I want to make sure that my daughter or my son gets this property. I want to avoid probate, but I want to be able to have benefit of this property while I'm still alive. And it's called a life estate. You transfer the property into yourself with a life estate with a remainder interest to your son, daughter, or friend, or whoever you may decide to deal with it. If you're not clear, if you just state that, then generally Medicaid and the nursing homes will look at it as even when you move out of that property, that life estate is still there for your life, and it can be rented. The property could be leased, and the kids don't get it while you're still alive. So it's to benefit you and to benefit you through the assisted living facility. And I will tell you that a lot of the people that discuss the Medicaid planning, it's a personal choice that you can deal with. The private wing of a assisted living facility can provide a lot more care sometimes than the Medicaid wing. So you want to think about your own self-interest. That's something to discuss with your estate planning attorneys. But in this purpose, I just want to say that a life estate is another way where you can transfer the interest after your death without going through probate, and it can be an effective tool. If you have questions in regards to this or other questions regarding real estate or other matters, you can call me at 603-883-5501, Dan Marr at 603-883-5501, or you can check out our website at nashwallaw.com. That's nashwallaw.com. Thank you. Look forward to the opportunity to work with you. Bye-bye.